So I think the subject of Professor Berlingieri lecture towards a wider unification of the law of the sea is just in the line of thought that Mr. D'Amico has expressed right now. Please.
Thank you, ladies and gentlemen. I should like, first of all, to clarify that the translation of the title of my speech is not correct. Law of the sea today is considered to be international public law, whilst insofar as private law is concerned, the terminology in English which is used is maritime law. So you have to consider that I'm not speaking about the law of the sea, but about maritime law. The title I gave is the same title my grandfather gave to a book in 1918 when he wrote a book with a commentary of the 1910 Collision and Salvage Conventions. Then he wrote another one in 1931 with a commentary on the 1924 conventions, the Hague Rules, and the Limitation of Liability Convention. So I copied from him the title, also because I remember him with great affection. This title has a meaning in Italy today because a number of, precisely 3 maritime conventions are in the very near future being ratified or acceded to by Italy. The 3 conventions are the 1976 Convention on the Limitation of Liability for Maritime Claims, as amended by the 1996 Protocol, the Bunker Convention of 2001, and indirectly through the European Community, the Essence Convention, as amended by the Protocol of 2002. So it is important for Italy that these conventions become a part of the internal legal system. I shall say a few words first on the Limitation Convention. The Limitation Convention, as amended by the protocol, the purpose of the protocol was to increase the limits of liability, has been ratified by 52 states, including all the important maritime countries. The protocol, as I said, by which the limits have been increased, has been ratified by 37 states, but again, the most important maritime countries did ratify it. The law authorizing the Italian government to accede to the 1996 protocol, and this entails the ratification of the convention as amended, has been enacted at the end of last year. Regretfully, there was a time limit of 6 months for the government then to enact the implementation rules. And the time limit of 6 months has elapsed without the implementation rules having been enacted at all. Therefore, I heard 2 days ago that has been a 12-month extension for the enactment of the implementation rules, which are a condition precedent to the filing by the Italian government of the instrument of accession to the convention. In any event, let us hope that this time the implementation rules will be enacted, and I have to tell you that I contributed to the preparation of those implementation rules 10 years ago. And now they are on the table of the ministries, and hopefully they will be considered. I can't do anything more than that. In any event, just to touch a few points on the Limitation Convention, the limits are based on claims relating to every distinct occasion. This is an enormous change for Italy, where the limitation is based on the claims arising during a voyage. Besides the fact that the notion of voyage is very unclear, the period is very long. The distinct occasion may be less than what we would consider to be an accident. There has recently been a judgment of the Australian Federal Court relating to a vessel that I think is, I don't remember exactly where in Australia, but in any event anchored near a pipeline. And the anchor dragged, the pipeline first was moved to one side and then broken. And the gas, because a gas pipeline it was, came out. Therefore, the claimants the case is Strongwise Limited against ESSO Australia Limited. And the claimants maintained that there had been 5 distinct occasions during all the events that occurred. First, the anchor caught the pipeline, then it moved the pipeline was distorted, then with further movement of the engines back and forward, the pipeline was broken. So they maintained that there had been 5 distinct occasions. That meant that there were 5 times the limit. The court ultimately decided that there had been more than 1 occasion, but it decided that there had been 2 occasions, therefore the double of the limit. So the fact that the limit is per distinct occasion may increase, in actual fact, the amount of the limitation fund. The limitation fund consists of 3 portions. There is 1 portion for claims for death and personal injury, a 2nd portion for property claims, but they are not entirely divided because they merge together in the sense that the claimants for death and personal injury can, if the amount granted to them is insufficient, also participate to the distribution of the fund for property claims. The limits, I cannot give you the details, but I just want to say that the limits are based, there is a minimum limit nowadays of 2 million special drawing rights, SDRs, for ships up to 2,000 tons gross tonnage. And then it increases with increase of the tonnage. There is then a limit also. The limits are different. The limit for death and personal injuries is the double of the limit for property claim. There is then a 3rd limit for passenger ships. And the limit today is 175,000 SDRs based on the number of passengers the ship is able to carry. Therefore, not on the number of passengers the ship is actually carrying in a single voyage, but on the number of passengers the ship is authorized to carry. Therefore, the ship may have maybe 50% of the number, but the limit is based on the total number and then distributed amongst the claimant. The convention, the LLMC, Limitation Convention, provides for what is called a rapid amendment procedure of the limits. This rapid amendment procedure has been now invoked by the government of Australia. The government of Australia has recently made an application to IMO. IMO is the organization competent, and I must tell you that the limits are, the increase of the limit is decided by the IMO Legal Council and not by a conference. There is a very complicated procedure, but I just want to tell you this. Australia has made an application based on the maximum limits that may be the amount that can be increased. And the outcome of that would be that the limits would double, according to the Australian proposal. But the Australian proposal has not yet been supported, as the convention provides for, by 50% of the member states. Therefore, it's still not certain that the proposal will go through, but it is rather likely that it will go through. Then it will have to be discussed in the legal committee of IMO, and a decision must be taken, and there is a certain specific majority which is required. But to give you just an example, for an 80,000 gross registered ton ships, the limit would increase from 26,200,000 SDRs to 59,589,000 SDR, so more than the double, if this application will be granted. This is the first convention that is expected to be acceded to by Italy, and which is in force in a large number of countries. The second convention is the Bunker Convention. Also in this respect, the government has been requested to make certain implementation rules insofar as the compulsory insurance, which is provided for by the Bunker Convention, is concerned. I want to tell you that insofar as Italy is concerned, the decision to accede to the Bunker Convention has entailed the decision to ratify the Limitation Convention, because the Bunker Convention provides that its provisions will not affect the right to limit liability, global liability of the ship owner, based on international conventions or national legislation. And after referring to international convention, article, if I remember well, 5 of the Bunker Convention says, such as the Limitation Convention. Therefore, it must be a type of limitation that is along the lines of the LLMC. That has entailed the necessity for Italy. The Italian government is always very keen to consider all rules relating to the protection of the environment. Therefore, it was decided to ratify the Bunker Convention, as has entailed also necessarily the decision to become party of the Limitation Convention. Then we have the Essence Convention. The Essence Convention will become part of the law of all the countries of the European Community pursuant to Regulation 392/2009 of the European Community. This regulation provides rules on the carriage of passengers and on liability and insurance. And it provides that insofar as liability is concerned, the rules adopted will be those of the Essence Convention as amended by the 2002 protocol. The regulation provides that the provisions of that regulation will come into force by 31st December 2012. Unless the convention, as amended, will be ratified either by the community or by the individual states of the community before that time. Therefore, the deadline will be end of 2002, when the Essence Convention will become law within the European Community. That is important also because whereas the Convention by itself applies to international carriage of goods, carriage of passengers. I have always carriage of goods in my mind. The regulation provides that the scope of the uniform rules will be extended also to coastwise trades, to national trades. Therefore, there will be only one legal system applicable within a certain deadline for international and national carriage of passengers throughout Europe. So that will be quite a big change because at present, most of the international conventions relating to carriage of goods or passengers apply only in respect of international carriage of goods. So it is expected that by the end of the year 2012, this this system will become law. I must tell you that so far the Essen Convention has received a very limited number of ratifications.